Welcome, dear learners. In the last class, we learned about new drugs and cosmetic rules 2019 that apply to all the new drugs, investigational new drugs for human use, clinical trials, bioequivalence studies, and bioavailability studies. We learned about permission from the Drug Controller General and clearance of the Ethics Committee for conducting the clinical trials and various other provisions. Also, we learned Cosmetic Rules 2020, which are the rules to codify and update the rules relating to cosmetics separately. Further, we learned about the Narcotics and Psychotropic Substances Act. Under that, we learned the definition of the narcotic substances and psychotropic substances. We learned different provisions as per the Act and the punishment for contravention of those provisions. We had learned that even consuming narcotics and psychotropic substances in a small quantity is a punishable offense. And lastly, we knew the commercial quantity of different narcotic and psychotropic substances. So this brings an end to different acts about the poisons. In continuation with the laws in relation to the poison, today we shall understand different penal provisions about the poison. In the previous classes, we learned that the parliament passes bills and once they get the assent of the president, they become an act. Code is generally a large body of the law and especially a systematically arranged collection of law on a particular subject. Whatever that is passed from the parliament that becomes the legislature becomes the statutory law, and the what are the decisions given in the court or judgments becomes the case law. So written, properly documented, passed from the parliament are the statutory law. So under statutory law, Constitution of India and the different acts that has been passed from the parliament are the statutory laws. In that sense, the Indian Penal Code and the Criminal Procedure Code are the large set of laws that deal with the criminal prosecution in India since the time of Britishers. The Indian Penal Code is the body of law framed by the Britishers and came into force on 6th October 1860. This classifies all possible crimes and prescribes punishment for them. It has 23 chapters and 511 sections. Chapter 16, which has the section 299 to 377, deals with the offences affecting the human body and is most relevant for the medical practitioner. Similarly, the Criminal Procedure Code deals with the powers of the criminal code and prescribes the procedure to be followed in the criminal cases. It came into the force on 25th January 1974. Also, the Civil Procedure Code of 1908 addresses the issues and punishments related to the civil matters. Recently, to improve the criminal justice system in India, the government came up with a proposal to amend the Indian Penal Code, Criminal Procedure Code, and Indian Evidence Act. Indian Evidence Act is an act that prescribes the procedures regarding the production of evidence before the court of law. The government came up with the Bharatiya Nyaya Sanhita, which will replace the Indian Penal Code, Bharatiya Nagrik Sanhita, that will replace the Code of Criminal Procedure, and the Bharatiya Sakshya Adhiniyam, which will replace the Indian Evidence Act. Actually, with the intention to improve the criminal justice system, the age-old Indian Penal Code, Criminal Procedure Code, and Indian Evidence Act were supposed to be replaced by these Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Samhita, and the Bharatiya Sakshya Adhiniyam. The bills were passed from both the lower and upper houses of the parliament and got the assent of the president on 25th December 2023. But due to certain administrative reasons, the act has been withheld till further orders, and to date, earlier law is applicable as of now. So, for our better understanding, we will learn what are the important provisions under the Indian Penal Code related to toxicology and what changes has been made under the Bharatiya Nyaya Sanhita. So under that, these are the sections that are important for us. The section 85 of IPC, section 86, 272 of IPC, 273, 274, 275, 276, 277, 278, 284 of IPC, and 324, 326 and 328 of these all IPC are relevant for our toxicological purpose. We will take all of these sections one by one subsequently. So coming to section IPC 85, that says that act of a person incapable of judgment by reason of intoxication caused against his will. That itself says that nothing is an offense which is done by a person who at the time of committing the offense was under the influence of intoxication, was incapable of knowing the nature of the act, and that he was doing what either he was not knowing what he was doing is either wrong or contrary to the law, provided that the thing which intoxicated him was administered to him without his knowledge and against his will. So, if he has been intoxicated without his knowledge or against his will, and in that condition, if he commits any offense, then it will not be considered an offense or he will not be punished for that offense. The same provisions has been brought under the clause 23 of the Bharatiya Nyaya Sanhita. There is no change in the Bharatiya Nyaya Sanhita regarding this section, and it is under the clause 23 in Bharatiya Nyaya Sanhita. Further, for better understanding of this 85 section, we need to understand the section 84 that came from the M. Norton's rule on developed by the Britishers. So, before coming to the section 84 of IPC, I would like to share this interesting case of M. Norton's with you. So, this on January of 1843 at the parish of Saint Martin. This is the parish of Saint Martin. This church, in front of that church, this incident is of in front of this church, parish of Saint Martin, in the middle Essex of the United Kingdom. The Daniel M. Norton took a pistol and shot the Edward Drummond. Edward Drummond was the secretary to the Prime Minister of that time. At that time Prime Minister was Robert Peel, and that fire injured the Edward Drummond fatally. Meg Nortons, making no effort to escape, was immediately arrested, and his statement to the police gives some insight into the state of his mind. He stated at the time of his arrest that the Tories in my native city had compelled me to do this. They follow and prosecute me wherever I go and have entirely destroyed my peace of mind. They followed me to the France, into the Scotland and all over the England. In fact, they follow me wherever I go. I cannot sleep nor get any rest from them. I believe they have driven me into the consumption. I am sure that I shall never be the man I was. I used to be of good health and strength, but I don't have it now. They have accused me of the crimes which I am not guilty even of. In fact, they wish me to murder. It can be proved by evidence. That is all I have to say. This was basically a statement given by the M. Nortons at the time of his arrest. So you can understand with these words what type of mental status, and he appears to be in certain delusion, that delusion of persecution. After that, Drummond, the person whom Meg Norton has shooted, died after 5 days, about 5 days later, and the Meg M. Nortons was charged with his murder. He pleaded not guilty by the reason of insanity. represented by the lawyers. At the trial, evidence was given of the shooting of the Drummond and witnesses were called on behalf of the defendant M. Norton to attest to the facts. He was not in sound mind of the sound state of mind at the time of the committing the act. Doctor also certified that his delusion behavior and found McNaughton was plagued by the intrusive paranoid thoughts about the police and the church official. Doctors found that he had fixation of thought about the ruling Tory party, the ruling party at that time, that he had been singled out for the persecution. The reason being that he has voted against the candidate in an election. So he had persistent thought that because he has voted against the ruling party, so the ruling party is planning to kill him. So this was in his delusion mind. So he, to defend himself, he was planned to shoot the prime minister of that time, and thinking the prime minister Drummond was killed. A fierce and fearful delusion caused a breakdown of the moral sense and loss of self-control, which left McNaughton in a state in which he was no longer a reasonable and responsible being. This was the findings by the jury. The jury found that McNaughton should be considered insane due to monomania and was therefore not guilty of murder. That is, not guilty by reason of insanity. The acquittal caused an uproar in the whole of Britain. So great was the controversy that the House of Lords requested the judges of Supreme Court of Judicature answer the questions regarding the culpability of insane and use of insanity as a defense in the criminal trial. As there was no recognition of temporary or partial insanity in the English law before this incidents, it had to be decided whether McNaughton should still be considered insane and therefore not guilty of murder. The judicial lords decided McNaughton was not guilty and nor could others be, provided the accused met a special threshold. The presumption was that every defendant is sane, but this could be rebutted if defendant could prove their insanity. So this was the final decision of the Supreme Court of the Britishers, that every defendant shall be assumed as insane, sound mind, but this could be otherwise if the defendant is able to prove that he is not of sound mind. So based on that, they had come with the certain rules that to do so, they had to satisfy the following test. What following test? That these provide for the legal definition of insanity. They provide that a defendant wishing to rely on defense of insanity must show that they labored under the defect of the reason. Reasoning was defected, caused by disease of the mind, so that either he did not know the nature, quality of his act, or that he did not know what he was doing was wrong. So these were the, if such things are there, then they will be assumed as under the insanity. And this was the finding of Supreme Court, and this came to be known as the McNaughton's rule. McNaughton's rule, 1843. Before this, there was no rules like this related to the insane persons. From this McNaughton's rule, the section 84 of Indian IPC has got developed. Act of a person of unsound mind. Nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to the law. So a person with unsound mind, if it is proven that at the time of the act he is of unsound mind and he does not know the nature of the act, what he is doing, so he will not be held guilty and he will be not subjected to punishment. Further, this unsoundness of reason for unsoundness of mind could be due to the idiocy, due to insanity, even due to drunkenness. and hypnotism and the mental decay as that occurs in the old days. So this same 84 section of IPC wherein it is applied in case of involuntary intoxication. So under the influence of the intoxication or drunkenness, a person becomes of unsound mind. So a person becomes of unsound mind and does not know the nature of the act, what he is doing. So he shall not be held responsible for the offense. That is what the section 85 of IPC says. So this 85 of IPC has also come from the section 84 of IPC, and the section 84 of IPC has come from the M. Norton's rule of the Britishers. So coming to the 86 of the IPC. Now there is certain difference in the Indian Penal Code. Now the condition is that if the intoxication offense requiring a particular intent or knowledge committed by one who is intoxicated. So if that intoxication has been done with his knowledge and with his will, then he will be held responsible. This is the interesting clause, that if he has been intoxicated without his knowledge and without his will, then the act he is doing or offense he is committed, he will not be held responsible. But where he has been intoxicated or he has lost his soundness of mind due to intoxication with his knowledge and with his will, then he shall be responsible for the whatever offense that is being committed by him. For example, so the difference between 85 and 86 can be understood with the example. If suppose X, a person, mixes alcohol in the cold drink of Y without his knowledge. So Y is not knowing that someone has mixed cold drink in his glass, and Y he comes under the influence of that drug or alcohol, and he goes out and beats Z. So Y shall not be held responsible for his act as per section 85 of IPC. At the same time, if Y drinks alcohol voluntarily, so much so that he loses self-control, and then he goes and beats Z, in that case, he will be held responsible as per section 86 of IPC. So 86 of the IPC says that in cases where an act done is not an offense unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the things which intoxicated him was administered to him without his knowledge or against his will. So if he has been voluntarily intoxicated, then it will be assumed that he had the same knowledge, but intention could not be there. So in the criminal justice system, although this is a part of the injuries and the medico-legal aspects of injury in the forensic medicine, but slightly I will share with you that in a definition of murder or a culpable homicide, we usually think the intention, but there are two things involved in that. One is the knowledge component and the intention. Knowledge component, for example, I will share a case where parents have this notion that putting their child, a 5-year or 3-year-old child, before the crocodile will increase the stamina and will make their children very powerful in future. They have this notion in the mind, thinking that they put the child before the crocodiles, and the crocodiles eats the children and the child dies. Now think, will you held the parents responsible for their act? Will you charge them under the culpable homicide or murder? The answer to this question is yes. The parents shall be punished under the culpable homicide. Why? Because you will say that there is no intent, there is no intention to kill the child, their own child. But once you are an adult, you have crossed certain age, that it will be assumed that you have sufficient understanding and knowledge that this particular act can be dangerous. So knowledge component comes here, that it will be assumed, it will be understood that parents should have this much of understanding that this particular act can be fatal to their children. And even though they are performing that act, that means they are not, and they are of sane mind. So they will not be assumed that they are of insane minds. So they will have to prove the insanity or whatever unsoundness of mind under the either idiocy or the hypnotism or the intoxication, like that. So unless that is not there, so they will be held responsible. So in the criminal justice system, both knowledge component or intent shall be satisfied. So if even though he has the not knowledge, but he has intention that he want to kill somebody, but he has not knowledge that it will not lead to the death, but he survives, then the even that case the he will be intention will be seen, that what was his intention. Even slight injury may be punishable with the culpable homicide because there was intention to kill. So knowledge component or intention component is involved. So, and this 86 of the IPC has under the Bharatiya Nyaya Samhita is clause 24. So 85 is clause 23, and now the in the BNS clause 24 is this 86 of the IPC. So, coming to the next IPC that is relevant to us is the section 272 of Indian Penal Code, that is adulteration of food or drink, adulteration of food or drink intended for the sale. So whoever adulterates any article of food or drink so as to make such article noxious as food or drink, intending to sell such article as food or drink, knowing it to be likely that the same will be sold as a food or drink, shall be punished with imprisonment of the description which may extend to 6 months or with fine which may extend to 1000 rupees. So adulteration of food or drink, either selling of such foods, knowing that it will be sold, it will be given to the some other person. If someone adulterates any article or food, then he will be punished for 6 months or with 1000 of fine. The same has been included under the BNS clause 274 with a slight change that fine has been increased to 5000 rupees. So this is the under 272 of the IPC. Then 273 of the IPC is the selling of these adulterated noxious food drinks. Whoever sells or offers and exposes for sale as a food or drink any article which has been rendered or has become noxious or is in a state of unfit for food or drink, knowing or having reason to believe that same is noxious as food or drinks, shall be punished with imprisonment for either description which may extend to 6000 and 1000 rupees. Again, this has been included in BNS 275 with a fine increased to 5000 rupees. So this clause is related to the food poisoning. If someone sells the food poisoning product and with his knowledge, then he will be held responsible and punished under this section. Adulteration of drug. If whoever adulterates any drugs or medical prescription in such a manner as to lessen the efficacy or change the operation of such drugs or medical preparation, or to make it noxious, intending that it shall be sold or used for, or knowing it to be likely that it will be sold or used for any medical purpose, or if it had not undergone such alteration, shall be punished with imprisonment for a description of 6 months or 1000 rupees. So adulteration of drugs is punished with the 6 months or 1000 rupees. Under the BNS, this clause is under 276 of the BNS with a change of imprisonment up to the 1 year and fine increased to the 5000 rupees. This slight change has been made under the new penal code, you may say, Bharatiya Nyaya Samhita. Further, the sale of adulterated drug. Sale of the same adulterated drug is punishable with a 6 month or with fine which may extend to 1000 rupees. So under this BNS, this has included in the clause 277 with a just only increased fine of 5000 rupees. Further, the sale of drug as a different drugs or preparation. So whoever knowingly sells any drugs or offers or exposure for sale issues from dispensary of the medical purpose any drug or medical preparation as different drug or medical preparation shall be punished with imprisonment of either description which may extend to 6 months or of the 1000 fine. In the BNS, it is included in clause 278 and with a change of increased fine of 5000 rupees. So, sale of drug as different drug or preparation. So, means adultering slightly difference means that label is of different drugs but inside it is different. So, in that case, he will be held under this section of IPC, that is IPC 276. Further, 277 is the fouling of public spring or reservoir. So, whoever voluntarily corrupts or fouls the water of any public spring or reservoir so as to render it less fit or for the purpose of which it is ordinary use shall be punished with imprisonment of 3 months or with fine which may extend to 500 rupees. So, this is about the water pollution. So, whoever pollutes the water to render it unfit or even less fit is punished under this section. Under the BNS, this slight change with imprisonment increased to 6 months and fine increased up to the 5000 rupees. So, after this, the section 278 of the IPC that says that making atmosphere noxious to the health. Whoever voluntarily vitiates the atmosphere in any place so as to make noxious to the health of a person in general, dwelling or carrying or business in the neighborhood or passing along a public way shall be punished with a fine which may extend to 500 rupees. So, environmental pollution, those who are causing the environmental pollution and that is noxious to the health of person who are normally living in that surrounding shall be held responsible under this section. So, even noise pollution can be included under this section. Those who are creating unnecessary noise may be included and punished under this IPC 278. And now this clause has been included under the BNS as 279 with a change of imprisonment up to 6 months, and earlier there was no imprisonment, so imprisonment has been included of 6 months and fine increased to 1000 rupees. So, this is the IPC 278, that is making atmosphere noxious to the health. Further, 284 of IPC, that is the negligent conduct with respect to the poisons. So, whoever does with any poisonous substance any act in a manner so rash or negligent as to endanger human life or be likely to cause hurt or injury to any person. Definition of hurt and injury is also defined under the IPC. Hurt under the section 319 of IPC and injury under section 44 of IPC. So, you must read those things also. To any person or knowingly or negligently omits to take such order with any poisonous substance in his possession as is sufficient to guard against any probable danger to human life from such poisonous substance shall be punished with imprisonment of either description that may extend to 6 months or with fine that may extend to the 1000 rupees or both. So, whoever is responsible for handling the poison is negligently or rashly handling the poison resulting in the endangering the life of the human or causing hurt or likely to cause injury to any person shall be responsible under this section. For example, a housemaid working in your house leaves a toilet cleaner on the table which is the place not to be kept and that which contains the acid, and a young child is there in your house and he drinks believing it to be water. So, now the person, or not just the housemaid, any person can be in place of her. So, a child is drinking because of negligent handling of that poisonous substance and he sustains injuries or even maybe dangerous to life. In that case, those person may be held punished under this section of the IPC, that is 284 of IPC. This has been included under clause 286 of the Bharatiya Nyaya Samhita with an increased fine of 5,000 of rupees, and the punishment of 6 months is continued. So this is IPC 284. Now IPC 324, that is the voluntary causing hurt by the dangerous weapon or the means. Here in the dangerous weapons include the any instrument used for shooting, stabbing, cutting, or any instrument which is used as a weapon of offense is likely to cause death. So no, we are not concerned about dangerous weapons. We are concerned in the dangerous mean. Under the dangerous mean, if a person uses poison or any corrosive substance that can cause hurt to the person by means of any substance which is deleterious to human body, to inhale or to swallow or to receive into the blood, here also the poison can be included. So in the different means, the poisonous substance can be included and that causes hurt to the person. In that case, the person will be punished with an imprisonment of 3 years or with fine. Here the reduced punishment is mentioned under the 334 IPC, in which on the grave and the sudden provocation, if he causes hurt to that person by dangerous weapon or means, in those cases on the provocation, if he is doing hurt by dangerous weapons or means, in that case the punishment is lesser. Still the punishment is there, that is mentioned under the section 334 of IPC. Under the BNS 2023, the same provisions are under the clause 118 of the 118 clause 1, with the fine mentioned earlier. The fine amount was not mentioned, so fine exactly mentioned as 20,000 rupees. So this is the minor change in the BNS 2023. Further, the IPC 326 says that voluntary causing grievous hurt by the dangerous weapons or means. So there was the hurt, the definition, any bodily pain, disease or infirmity caused to a person by another person. So that is under 319 of IPC. So, and the grievous hurt is defined under the 320 of IPC. So you must go to that. Under that there are 8 clauses that should satisfy to produce the said that this is a grievous hurt. So if a person causes grievous hurt by dangerous weapons or means, whoever, except in the case provided by the section 335, again 334 is for the hurt and 335 is for grievous hurt on the sudden or grave provocation. In that case punishment is lesser. Voluntary causes grievous hurt by means of any instrument. So weapon, shooting, stabbing, cutting weapon or any instrument which is used as a weapon of offense is likely to cause death. They will be called dangerous weapons. And the dangerous means, these are the dangerous means of fire, any heated substance, by means of any poison or any corrosive substance. This is dangerous means. By means of any explosive substance, by means of any substance which it is deleterious to human body to inhale, swallow or to receive into the blood, by means of any animal shall be punished with imprisonment which may be extended to 10 years and shall also be liable to fine. So under the dangerous means, for our purpose there are these poisons. Here the poison may be used by means of any poison or a corrosive substance, by means of any substance which is deleterious to human body to inhale, to swallow or to receive into the blood. So here our perspective of poison is there. So under the BNS 2023, this is included under the clause 118 of 2 and shall be punished with imprisonment. For earlier this was 10 years only maximum. Now the punishment increased up to the life imprisonment and minimum of imprisonment for a term which shall not be less than 1 year and can extend to 10 years and also liable to fine. So this punishment has been increased under the BNS 2023 for the section 326 of the IPC. And the last IPC that we have to know is the IPC 328. IPC 328 is the causing hurt by means of any poison etc. with intent to commit an offense. So whoever administer to or causes to be taken by any person any poison or any stupefying, intoxicating or unwholesome drug or other thing with intent to cause the hurt to such person, or with intent to commit or facilitate the commission of an offence, or knowing it to be likely that he will be thereby cause hurt, shall be punished with imprisonment of either description for a term that may extend to 10 years or with fine. So, causing hurt by the means of poison or any stupefying, intoxicating, or unwholesome of drugs or any other thing with intent to cause hurt to such person, or with intent to commit or facilitate the commission of an offence. So this is a very important provision. Here all the drug facilitated crimes, drug facilitated assault, sexual assault, DFSA, that we will be dealing in the narcotics also, they are punished, they shall be punished under this section of IPC. And the same has been included in the clause 3.123 of the Bharatiya Nyaya Samhita. So these all IPC you have to know for the purpose of the toxicology. With this, thank you so much for today. Thank you.